I'm Rebecca Arvizu. I will be facilitating.
I'm putting in the chat the ICUJP link tree, and it's got a lot of information about books and movies that people have either directed or written, respectively, and uh, things that we have in file, like how to fight back against what's happening in Palestine and Israel with your hard-earned money and your time to be able to fight back against companies that are making money off the conflict. So yeah, there's a lot in there I encourage you to take a look at. And if there's anything in there that you think would be a good link for other people to know about, please let me know. That'd be great. Thank you.
I want to remind everyone before we get started that in the email that you received that gave you the information to log on to the program, you'll see there, in addition to what Rick put in the chat, but there are links to donate to ICUJP so we can continue putting on these great programs. So we highly encourage you to take a look at that, see if you can donate, if it's just one time, or even if you can set up a monthly donation. That will be great. And I see that Carol Francis is reminding that I should ask Rick, do we have a speaker lined up for next week?
We do. And Steve, I don't know if you'd like to talk about our speaker for next week.
Yes, I'm very pleased that Heidi Bogosian, an attorney and a co host with me, Jim Lafferty, and others of Law and Disorder Radio and Podcast, has just written a new book which examines the whole question of internet surveillance and secrecy and privacy. And she will be joining us next Friday. You'll get an announcement with more details early next week.
Great. Thank you, Rick. Thank you, Steve. So we're doing things a little bit different on this program. Normally, we have two different people facilitate and give the reflection, but I will be doing both. So this program, I'll try not to let it become the Rebecca show, though. Um, so I decided to take my reflection from the forward of this book. I don't know if you can see it here, defending my enemy. It's a book written by Arye Neer and Nair. I'm sorry, Steve gave me the pronunciation. He had recommended that I read this book, and he's used it as a reference for many of his great, articles. And so Ari Nair was the executive director of the ACLU National for many years, also a co-founder of Human Rights Watch. And he was a counsel that represented the Nazis on the what's commonly called the Skokie case, where the Nazis had marched through the town of Skokie, and they were challenged about that, and he ultimately won their rights to do that on free speech grounds. So with that, I'm gonna just go ahead and launch into. I'm reading the foreword to this book, which I think it was like, later edition that he wrote this foreword to it. So long after publishing Defending My Enemy, I was forced to consider whether I would take the same approach to the hate speech that played an important part in fomenting the genocidal crimes committed in the 1990s in Bosnia and Rwanda. In both cases, but especially in Rwanda, a direct link seemed to exist between broadcasts urging violence and the extreme violence that actually took place. In thinking about this, I decided that I could not defend the rights of Rwanda's radio television Libre de Mille Collines, RTLM, to broadcast messages calling on government forces and allied militias to murder all Tutsis. Yet this did not seem to me to require revision of my position that the Nazis should be free to march in Skokie, Illinois. How did I reconcile these positions? The Nazi March in Skokie took place in the United States, which provided a context where freedom of speech was not only protected legally, but also operated in practice. Whatever the Nazis might say was challenged and rebutted by a great many others. My defense of freedom of speech in Skokie was intended to maintain the widest possible latitude for expression. In contrast, in Rwanda, RTLM operated in circumstances in which the proponents of hate had exclusive access to most of those who heard its broadcasts. Licenses to operate radio stations had been denied to those who might offer contrary views. In effect, RTLM's broadcasts had an official imprimatur. The context was one in which the freedom to disseminate differing views was prohibited. If anything, it seemed to me that the different contexts of Rwanda highlighted the need to protect freedom of speech for all. Yet, it would have been absurd to defend RTLN's broadcasts as freedom of speech when the only broadcast messages that could be heard in Rwanda were its hate messages. Unfortunately, exclusive access also greatly magnified the impact of those genocidal messages. This focus on context reflects what may be considered the American approach to freedom of speech. Elsewhere in Europe, for example, the critical question about hate speech is its content. Not so in the United States. Speech may only be punished in the United States, the Supreme Court has made clear, when incitement of hatred takes place in circumstances where imminent violence is a likely direct consequence. The court has also held that violence by those opposed to a speaker cannot be a basis for silencing a speaker. Rather, the responsibility of the authorities in such circumstances is to protect the speaker against violence from those who wish to suppress views they may find offensive. As this book makes clear, Defending My Enemy, the litigation by the ACLU that established the rights of Nazis to march in Skokie did not establish any precedent. Judged only from the standpoint of its legal significance, it was not an especially noteworthy case. What has become customary is to cite Skokie as an example of how broadly freedom of speech may be protected. In the United States, I have heard people defend speech in a variety of circumstances by saying something like, well, if the Nazis could march in Skokie, then other examples of outrageous speech should also be protected. That the case is still of interest is a source of satisfaction to those like me who lived through the heightened emotions that it caused for many who were caught up in furious debates while the case was underway. We could not have guessed at the time that it would still be of interest so far in the future and that it would become such a lasting symbol of freedom of expression. All right, with that, then I'm just going to go ahead and launch into our presenter. I will give a brief introduction um, for him, but he really needs no introduction. He's our chair of ICUJP, Steve Rohde. He's a legal scholar, writer, lecturer, political activist. He practiced civil rights and civil liberty law for 50 years, past chair of the ACLU Foundation of Southern California, and past national chair of Bend the Arc, a Jewish Partnership for Justice. Also, on a personal note, I served with Steve for a few years on the board of the ACLU SoCal, where I got to know him and many other people who have really influenced my life and my perspective. And so I'm really looking forward to this presentation. So without further ado, we'll turn it over to you, Steve.
Thank you very much, Rebecca. And thank you for your reflection. Ari Nayar is a towering figure and a hero to me. I may have missed it, but in your identifying him, he was a child in Nazi Germany, escaped
Oh,
the
yeah.
Holocaust. And the notion that a Jew, that a survivor of the Holocaust could understand the power and importance of protecting free speech, I think speaks volumes. And I do encourage folks. There's a new edition of Defending My Enemies that is about to be published, and I encourage everyone to track it down. It's not irrelevant that we would begin today with that topic because depending on time and questions and answers, I hope to also weave into my remarks this morning how the Trump administration is conducting a wholesale attack on freedom of speech, freedom of the press, and academic freedom as part and parcel of this assault on democracy that I'm going to talk about today. I'm grateful to have these opportunities to gather my thoughts. Uh, you know that we have some time together here rather than a quick sound bite or even a short radio interview. I'm going to talk broadly about what's going on in the United States, especially from a constitutional standpoint, since that is my expertise. Um, uh, and then we'll be tracing some of the uh, Supreme Court cases that have taken place in the last 6 months, because I believe the United States Supreme Court is complicit in the rise of fascism and authoritarianism, along with sometimes a passive and sometimes an active Congress that is doing the same thing. Um, I'm going to save ample time for questions and answers because I know this group is filled with curiosity. And while I make every effort to unpack these legal issues, because I believe it's imperative that everyone in the United States understand the fundamentals of our legal system and understand what is going wrong in it today. Um, and I know you're also concerned about what are we going to do about this. And in my remarks, and I hope in questions and answers, we'll have a discussion about how people are resisting, how they are organizing and mobilizing to take back democracy. I do want to put this in a historical context. Um, you know, the Supreme Court currently is in the grip of a six-member super majority of highly reactionary justices, um, three of whom were appointed by President Trump himself. Uh, there is a struggling minority on the court made up of three proud, articulate women judges who are fighting back as they can in a series of eloquent, scathing, dissenting opinions from what the majority is doing in wreaking havoc to the U.S. Constitution and the rule of law itself. So that majority is fond of invoking their pet theory of originalism. They love to use a doctrine which was really only conjured up by the Federalist Society and a few conservative law professors a few years ago, to claim that the US Constitution is frozen in its 18th century amber, and that it does not adapt to ongoing changes in society and to the march of history and the arc of justice. And in doing that, they're so fond when it serves their purposes to celebrate the founders and the text of the Constitution and the meaning of the Constitution. Now, they only do it when it serves their interest to reach the conclusion which is preordained and then dressed up in fancy jurisprudence and legal language to make it appear as if it's dictated by history, law, and the Constitution. But they readily ignore the text of the Constitution and the history of the Constitution when it would not serve their purposes to do so. This was on full display a year ago in the aptly named case Trump versus the United States of America. In that case, in a shameful 6-3 decision, the majority, in an opinion by Justice Roberts, whom I may have a few things to say about in the course of this talk, invented absolute presidential immunity for presidents who commit crimes. To say it is to evidence how shocking it is, because no originalism would bring you to that conclusion, since there's not a word or a concept in the US Constitution that justifies granting a president absolute immunity. In fact, the text of the Constitution says no such thing. It does provide for immunities. There are certain immunities for senators when they are on the floor of Congress from in the speech or debate clause from what they say on the floor of Congress. States knew about executive immunity, and some state constitutions provided for immunity for governors. The founding fathers were well aware of the notion of immunity. James Madison had it as a possible topic at the Constitutional Convention, and it was never taken up by the founders. So Roberts and his cadre invented presidential immunity. And I think that was the tip of the iceberg as to what is coming to pass in these last 6 months. Now, the other fundamentals of the Constitution that are being trashed today are even more fundamental and are in the Constitution and in the early understanding and application of the US Constitution. What I have in mind are separation of powers and checks and balances. The founders had seen the history of strife in Europe including religious strife and religious wars. They understood royalty and monarchies and tyranny. They fought a war. They were living only years after winning the Revolutionary War to throw off a despotic monarchy, and they did not want to recreate such a system in the United States. So they put at the front of the original Constitution, Article 1, creating Congress with a Senate and a House of Representatives. The people's branch of the government was put first in the Constitution. If the originalists are looking at the structure and history of the Constitution, they would take note of the fact that the people's branch is first in the Constitution. The president is second in the Constitution, and then the courts. They divided power. They understood the risk of concentrating power in the hands of any individual or group. James Madison in the Federalist Papers, and as well as Alexander Hamilton, wrote about the need to disperse power into separate branches, and that those branches would then be a check and balance on the other branches, so that Congress passes laws. The president, in his or her someday oath, is bound to faithfully execute the laws. That's the duty of the President of the United States. The President of the United States does not make law. Congress makes laws. The President can veto laws, but the Congress can override that veto by a 2/3 vote. That is a check and balance on an excessive president. And the Supreme Court, the Constitution says that the federal law is the supreme law of the land, and the Supreme Court, in early decisions through John Marshall, Justice Marshall, said it is the duty of the Supreme Court to say what the law is, but even the Supreme Court can be overturned by constitutional amendments through the amendment process of the U.S. Constitution. Overriding all of this are the impeachment clause to remove presidents, Supreme Court justices, other judges, and elected officials through impeachment. And there are a variety of other checks and balances woven into the Constitution. What the framers did not realize, and many people overlook the fact, that there were no formal political parties at the time the founders met in the State House in Philadelphia to hammer out the U.S. Constitution. There were caucuses, you might say. There were groups of like-minded founders that thought alike. It would emerge that the battle over the ratification of the Constitution would produce groups, the Federalists on the one side supporting the new Constitution and the anti-Federalists on the other side. But they did not anticipate in any structural way the growth of political parties. Now, very quickly, as contentious human beings will do, the Federalist Party emerged and the Democratic Republican Party would emerge, known as the Republican Party, and then down through history. and Adams and Jefferson and others began to align into those political parties. I say that because I believe we are in a constitutional crisis today. That has been bandied about. Some people say we're approaching a constitutional crisis. Others say it's threatened. I'm convinced that we are in a constitutional crisis. And the key reason for that is that every branch of our government today is in the grip of the Republican Party. The presidency and the executive branch certainly is. Congress, including the House of Representatives and the Senate, although with slim margins, are in the grip of the Republican Party. And most importantly for today's conversation, the U.S. Supreme Court is in the grip of the Republican Party. All six of those controlling the supermajority were nominated by Republican presidents and have consistently, for years now, even when their majority was slimmer, have been marching to the tune and the platform of the Republican Party. There is a new book that I have reviewed for the LA Lawyer magazine called Lawless. You can, by Leah Littman, the co-host of Strict Scrutiny, an extraordinary podcast that digs deep into the Supreme Court and the rule of law. She demonstrates convincingly that this supermajority and the majority before it have simply taken platforms from the Republican Party, dressed them up in legal language, ignored constitutional doctrines when they wish to, and have implemented that Republican agenda. And it was in the first Trump administration that Donald Trump began to likewise, through the executive branch, implement that agenda, and now elected by a minority of popular votes, but enough to satisfy the Electoral College, Donald Trump has been reelected, but is using and has used the last 6 months in a sweeping example of grasping for himself presidential power. That brings me to a second doctrine that the right wing has invented called the unitary executive theory. And I've promised you, to the best of my ability, to boil down these legal concepts so that we all understand them and see what mischief they're causing in our country today. And the unified executive theory is one of those. Again, cooked up by conservative professors, lawyers, and the Federalist Society, and then increasingly by Supreme Court justices. The unified executive theory claims that all executive power and to some extent all power of the entire federal government resides in a single person, the person that occupies the White House. That all executive branches are subject to the president's power and authority, and that no congressional act can interfere with the president's unilateral, unitary power. And that is coming to fruition in the court decisions we're seeing right now. And I will weave that into my remarks as I discuss those cases. And I will discuss the dissents, and that's my vehicle to criticize the unitary executive theory. It's impossible. It's impossible.
You'll need to unlock your iPhone first.
Wow. It's impossible to canvass what has happened in the last 6 months, in even the time we have together. It is a shattering attack on the rule of law and our government. Whole lectures could be spent on the destruction of diversity, equity, and inclusion. Whole programs could be done on the dismantling of federal employment. In addition to everything I'm talking about, President Trump deployed Doge and Elon Musk to run roughshod through the federal government until he fell out of favor. It will take, when we recover our democracy and retake power, several generations to undo what Trump is doing in this 6 months and the time he may have left in office. But my purpose today is to give this as much of a clear understanding as possible. I understand that upwards of 400 lawsuits have been filed against the Trump administration in the last 6 months. I want to applaud the brilliant lawyers and organizations that have brought many of these lawsuits, along with attorneys general in Democratic states, upwards of 22 to 23 state attorneys general, including our own Attorney General Bonta and others, have filed these lawsuits. They are struggling to live up to that Constitution and the Bill of Rights that came a few years later, to hold the Trump administration accountable. And brave judges appointed by Republicans and Democrats have been pushing back on what the Trump administration is doing. Until we reach the United States Supreme Court, which I will focus on in detail, this last 6 months is one of the greatest celebrations of a democratic constitutional institution. Lawsuits, advocates, judges, and the judicial system in real time fighting back against an authoritarian fascist government as it is happening. And were it not for those 6 conservative justices, this would be a home run for the court system. Those judges in the lower courts are doing the hard work that our judicial system demands of them. And in what I'm about to say, I am previewing the disastrous opinion that the court issued in the CASA case regarding national injunctions. And I will expand on that in a moment because it's critically important. But what is so abusive and shameful about recent Supreme Court decisions is that they are blocking decisions made by scores of district judges and appellate court judges who have spent weeks hearing evidence, reviewing sworn declarations and testimony, reviewing documents, writing opinions, in some cases 100 pages or more, explaining their reasoning and why they are enjoining the Trump administration's worst executive orders and the implementation of those orders by his newly appointed minions in various government positions. Just a few Sundays ago, on July 13, the New York Times did a service, and in all of this, I encourage you to track down these materials. I encourage you to read these Supreme Court decisions. I encourage you especially to read the dissents from Justice Sotomayor, Kagan, and Jackson. They are writing to you and me. They are writing to the public. These are dissenting opinions filled with clarity and outspoken exposure of what the majority is doing. And that's happening originally in the lower courts. So the New York Times published a full page, and you can search for this in the July 13 edition of the New York Times, How Judges Describe Trump's Actions. And they have excerpted very brief quotes from these judges. And this morning, I'm just going to quote a few from judges appointed by Republican presidents, if anyone thinks this is a slanted Democratic conspiracy among the lower court judges. In the area of immigration, in a powerful opinion written by Judge Wilkinson on the Fourth Circuit Court of Appeals, appointed by Ronald Reagan, said, referring in each of these cases to what Trump is doing, this is a path of perfect lawlessness, one that courts cannot condone. Roger Gregory of that same court, appointed by George Bush, as is becoming far too common, we are confronted again with the efforts of the executive branch to set aside the rule of law in pursuit of its goals. Judge Gallagher, appointed by Donald Trump. Defendants meaning Trump, have provided no evidence or even any specific allegations as to how Christian or any other class member poses a threat to public safety. This is a court of evidence. She was referring to an asylum seeker that was deported to El Salvador. A judge appointed by George Bush said, there's no doubt this retaliatory action chills speech and legal advocacy, or that it qualifies as a constitutional harm. Judge appointed by George Bush in the state of Washington. The government's arguments are not persuasive. It is not an especially close question on this record. Judge in the Western District of Washington, appointed by Ronald Reagan. I've been on the bench for over 4 decades. I can't remember another case where the question presented is as clear as this one. This is a blatantly unconstitutional order, and that is the one where Trump attempted to abolish birthright citizenship protected by the 14th Amendment. A judge appointed by George W. Bush. The executive order contradicts the text of the 14th Amendment and the century-old, untouched precedent that interprets it. A few more. A judge appointed by Ronald Reagan. It's hard to fathom a more straightforward display of arbitrary and capricious actions than the defendant's actions here. Another one, Donald Trump appointee, that argument is nonsensical. And a Ronald Reagan, I have never seen government racial discrimination like this. These are judges, you can see it, appointed by Republican presidents, including Donald Trump himself. I dwell on that to demonstrate briefly the breadth and depth of why judges are identifying Trump's lawlessness and his assault on the Constitution. So these cases are getting to the Supreme Court, and they are rendering shameful decisions under what is known as the shadow docket. I think by the end of our talk today, and when I send you by email today's quiz that each of you is expected to answer and send back by the end of the day, the shadow docket. So let me start here. All of us, whether we've gone to law school or not, are aware of Supreme Court decisions. They affect our lives. They affect every contour of American society. Largely, we expect the Supreme Court, when they accept a case, and they don't accept many, to receive briefs from both sides, to often, on important question, receive amicus briefs. Amicus, Latin for friend, and amicus curiae, friend of the court briefs, written by interested parties on both sides of any disputed issue to hopefully assist the court, but clearly to advocate for a particular viewpoint. These friend of the court briefs are very important. Then the justices consider all of those arguments, and they schedule oral arguments. These are the famous arguments, some of which have been recorded and made available. We see photographs of the august Supreme Court chamber in Washington, D.C., where 9 justices meet, and they hear argument for hours on end from each side in these important constitutional questions. Then they step back into their chambers. They reread the briefs. They ask their law clerks to research the legal questions that are presented. And they meet in conference in what I'm told, and have never been inside, a large conference room in which only the 9 justices sit, and they discuss, debate, and probably argue about the case at hand. They then write opinions depending on where a majority is emerging. A majority opinion, concurring opinions which agree with the result in the case, but may have other legal reasoning they want to put on the record to explain why they may agree or slightly disagree with the majority. And then we have dissenting opinions. Justices who disagree and write elaborate dissenting opinions. And then all of those opinions are published for the American people, for the lawyers in the case, and for lower court justices to understand the guidance and the precedent that the Supreme Court is announcing. That is how the system is expected to work by and large to uphold the rule of law. All of that has been thrown aside in the last 6 months, and to a lesser extent with this court for the last few years. How has that been done? There are rules in the Supreme Court to hear emergency requests. I always say, even in lower courts, someone's about to cut down the trees. And if the tree gets cut down, you can never put it back. There are emergencies in our system. There are men and women about to be executed who have raised fundamental flaws in their case. To wait for everything I just described, to have them executed before the court can act, it would be a travesty, although sadly the Supreme Court has allowed that to happen. So there are rules for emergency stays of lower court rulings. They are rare. They are extraordinary because everything I've told you is how the system is expected to work in a prudent and thoughtful and considerate manner. The current majority has seized on emergency stays, and that is what one law professor coined the phrase shadow docket to describe those emergency stays. I call it the shameful docket. The judges are using the shameful docket to stay the injunctions that have been adopted by those hardworking district judges. The district judges, and I'll give you a few examples in a moment, have looked at the evidence, and to maintain the status quo, they have enjoined what Trump is doing. And by and large, the appellate courts have upheld those injunctions and denied the Trump administration the request to stay those injunctions. Now, injunctions. The status quo on January 19 of this year was a certain set of laws, certain officials in executive branches, some appointed by Republicans, some appointed by Democrats. The status quo was the state of our government the day before Donald Trump took office. Donald Trump, beginning within hours of his swearing in on January 20, took out his Sharpie and began signing executive orders. He has signed an extraordinary number in the hundreds of executive orders. Literally, with the strike of a Sharpie, he has purported to change the status quo. He has fired inspectors general. He has ordered the firing of government officials. He has declared birthright citizenship does not exist in the United States. He has ordered the deportation of non-citizens under the Alien Enemies Act of 1798. He has run roughshod through the federal government in a series of orders which disrupted the status quo. Injunctions, and first temporary restraining orders and later preliminary injunctions, and after trial permanent injunctions, are meant to preserve the status quo. So all of those injunctions that I talked about, upwards of 194 injunctions, were put in place after serious deliberation to maintain the status quo that existed on January 19 before Trump took office. The Trump administration was upset by that. The courts were blunting what Trump and his enforcers wanted to achieve. So they drafted a pro forma request for emergency stays. And early on, talking about this a few months ago, I said that the Solicitor General, who is a former personal lawyer of Donald Trump's, and the new Justice Department had emergency stay applications on speed dial. Well, maybe Justice Sotomayor somehow hears what I'm saying. In one of her recent dissents, she said the government has emergency stay applications on speed dial. I'm not the inventor of that phrase, and we know what she meant, and you know what I meant. They have found such a favorable audience in these 6 reactionary judges. Thank you, John. That they put in very brief papers. It's done within days of what has happened in the lower courts, and compliantly the majority has been granting these emergency stays. Now, the emergency docket requires a showing of 3 things. That the side in the case asking for a stay has a likelihood of success on the merits of the case, that they are likely to prevail, and that it's likely that the lower courts were wrong on the law in granting those injunctions. A likelihood of success must be shown to justify an emergency stay. Secondly, the Supreme Court is expected to balance the equities. Who will suffer more harm from staying this injunction than granting it? And finally, what's the public interest in this injunction that the lower courts have granted? And should the public interest be served by allowing the injunction to remain in effect while the case goes forward on the merits to a final decision, which will then be reviewed on the merits, the underlying issues, by all the courts, including the Supreme Court? What is so shameful about this shadow docket is that the reactionary majority has thrown all of that aside. In some cases, this majority, facing hundreds of pages of precedent and analysis and reasoning, has issued a 4-sentence, per curiam opinion. They are unsigned. We only know who voted by who dissented. And with a couple rare exceptions, it's been the three dissenters that have told us what's up. It is in the dissents that the issues are laid out. The pros and cons are laid out because the majority's not doing that in their 4-sentence opinions. In some cases, they don't even have the decency to cite the 3 grounds that I just gave you, that any law student would get an F in a paper if they didn't cite the 3 grounds and why each of those grounds justified an emergency stay. It is shameful. It undermines our judicial system. The Supreme Court is at an all-time low in public opinion because of the havoc they've wreaked in our system. And instead, under the leadership of John Roberts, they are risking the reputation of this court in order to do Donald Trump's bidding. Because what happens in these cases? The status quo is disrupted, not protected, because Trump disrupted the status quo. Trump, and let's dwell on birthright citizenship for a few minutes, because that's perhaps the most visible and dynamic issue that's pending, and it is accessible to all Americans to understand what is going on. Several lawsuits, as soon as Donald Trump wrote his executive order saying that the only persons who are citizens are those born to legal residence in the United States. And in doing so, he clashed with the 14th Amendment. The 14th Amendment, written in the wake of the Civil War, said every person born in the United States is a citizen of the United States. They didn't specify the nationality of the parents or the legal status of the parents. Now, by common law, it was understood that the children of foreign diplomats temporarily in the United States who may be living in an embassy and give birth, those babies are not American citizens. That was understood by the founders, by those who adopted the 14th Amendment, and although conservatives have seized on that, it is simply an understanding. It does not, the exception does not swallow up the rule. For all those 150 years, my math's bad, since the 14th Amendment was adopted, every president, every Congress, every court has understood that children born even to non-citizens in the United States are American citizens. That's why it's called birthright citizenship. Birth goes with the territory in which you are born. No one, the Supreme Court has never questioned that doctrine. That is the status quo. Trump tried to disrupt the status quo by signing his executive order and ordering his agencies within 30 days to begin to implement that executive order, since under the unitary executive theory, Trump is king above all executive branches and agencies. A series of lawsuits were immediately filed challenging his executive order. They were filed by pregnant mothers, non-citizens about to give birth to a child who, under the executive order, would not be a citizen of the United States. They were filed by immigration organizations, and they were filed by 22 states who said that their entire system of public benefits, of registration, of birth certificates would be entirely disrupted if that executive order were to go into effect. Other cases were filed. That case, CASA, which is the named case that the Supreme Court ruled on, was filed in Maryland by the Institute for Constitutional Advocacy and Protection, and by the Asylum Seeker Advocacy Project Incorporated. A case called Barbara versus Trump was filed in New Hampshire by the American Civil Liberties Union, the Legal Defense Fund, the Asian Law Caucus, Democracy Defenders Fund. And those are examples of those brave, hardworking lawyers and legal organizations that have been bringing these cases. A case was filed in the state of Washington versus Trump. In each of those cases, serious debate and discussion and briefing and oral arguments were conducted, and preliminary injunctions were granted. In some of those cases, the judges said that while I have before me Barbara, a pregnant woman, or I have 22 states, or I have immigrant associations, in order to give complete equitable relief, I need to make my injunction national. Although I, a U.S. district judge, sit in one particular district and the appellate court covers a number of states, but not the entire country, to give complete relief, I need to grant a national injunction. Because in our mobile society, people move around. And I may grant Barbara, a pregnant woman, relief here in New Hampshire, but her mother might live in Massachusetts, and she wants to give birth with the comfort and support of her family in Massachusetts. So my injunction must not only be limited to New Hampshire, it needs to have national application. Also, the issue is national. I can't think of a more national issue that affects every person, every baby, every family than the 14th Amendment to the U.S. Constitution that applies to every state in the Union. So the issue is national. The issue, when it's litigated in one place, applies to all persons similarly situated across the United States. I hope it's become self-evident that after due consideration, these national injunctions make sense, but not to those 6 reactionary judges. So the CASA case reaches, and they combined it with the Barbara case, reaches the United States Supreme Court. And it issued its opinion on June 27, a few days before the end of the docket for this year. Now, in this case, they did write an opinion. So good for them that they gave some reasons. They looked back into English history because injunctions come from the Judiciary Act of 1798. And what was the nature of injunctions that we borrowed from British law and that the courts began using after the establishment of our federal court system? I'm not going to waste your time with the 6-member distorted history of English law, of American law, when it comes to equity. Equity is a concept that goes beyond certain statutes or legal principles. Equity looks at fairness and justice and whether, in this case, an injunction should be granted. Equity is flexible. It needs to deal with the facts and circumstances that are presented in a particular case. In short order, the majority said that national injunctions cannot be granted by an individual district judge or appellate court. They left open a limited exception for class actions. You've heard about lawsuits brought by a certain set of plaintiffs and similarly situated individuals. Class actions. Lots of class actions in consumer cases and someone challenging an automobile manufacturer for a faulty exhaust system. They bring that case in one district and they say, we're bringing it on behalf of all similarly situated people. That's a class action. It's a cumbersome process. You have to certify the class, but they did leave that door open. Well, the dissents in the CASA case are extraordinary. And just Google Trump v. CASA, C-A-S-A, or Birthright Supreme Court. You will find ample links to the dissents. In this case, Sotomayor wrote a dissent, joined by Kagan and Jackson wrote her own separate dissent. And I'll just excerpt a few provisions from these dissents because it speaks volumes to what I have been talking about all morning. Justice Sotomayor says the government asks this court to hold, no matter how illegal a law or policy, that courts can never simply tell the executive to stop enforcing it against anyone. The majority expects individual pregnant women around the country to bring their own lawsuit, to find a lawyer, one they may have to pay or one that is willing to be pro bono, to bring lawsuits in all 50 district courts around the country, to have a multiplicity of litigation. Maybe they'll find a Trump judge who denies an injunction, and that goes up on that track, and have these cases pending across the country. The Judge Sotomayor called that out, as did Justice Jackson. As far as irreparable harm to the government to stay what Trump did when it's been the law of the land for hundreds of years? She said the radical proposition that the president is harmed irreparably whenever he cannot do something he wants to do, even if what he wants to do is break the law. And now you can see the mentality of the criminal immunity case rearing its ugly head. It is the president being allowed to do what he wants for months while these cases work their way first through the appellate courts and then to the Supreme Court. In that period, when those executive orders should be enjoined, they are allowed to proceed. Full dress, full go ahead. Heads of executive departments who by congressional law can only be fired for cause after a hearing process have been fired. And the Supreme Court is allowing those firings to go forward. Yesterday, the Ninth Circuit held that executives of a consumer protection agency cannot be fired without cause. And that case is going to the Supreme Court. When the head of the National Labor Relations Board, a member of that board, was fired without cause, the lower court said that violates Congress. And there was no good cause, and the Trump administration was so arrogant they didn't even cook up any cause for that firing. And yet the Supreme Court, using the shameful docket, is allowing that to go forward. And many of you have heard by now that the Department of Education has been dismantled by executive order, and Trump is allowing the Department of Education to be dismantled, 1,400 people to be fired, while the question of whether Trump has the power to do so is being litigated in the lower courts and eventually in the Supreme Court. That's what is at stake here. And for time, I won't dwell on each of those cases. I've tried to summarize essentially what's at stake here. There are powerful lower court cases that are pending that need to be watched and monitored, that I've talked about on Law and Disorder and on the Lawyers Guild show on KPFK. Some of those shows are archived. But I promise time for questions and answers, and I promise time to talk about what are we going to do about it. I'm going to start straight across my screen and call on John Crampner.
Thanks for a very informative, if slightly depressing presentation. One of the things that kind of occurred to me for the first time while listening to you is that, two of the core precepts of this whole, Leonard Leo Heritage Foundation movement they're in contradiction. They're in flagrant contradiction with each other. On one hand, you have originalism saying we must obey the absolute letter of the original Constitution. You have the unitary executive, which says we're going to make shit up that is plainly in contradiction with the Constitution. Basically, it seems to me that the Supreme Court should now be called the judicial branch of the Republican National Committee. I also think that because the 6 majority justices have so thoroughly discredited themselves, that I would like to see things like district and appellate courts, for example, continuing to issue national decisions as a way of saying F you to the Supreme Court and things like that.
Yes.
Anyway, thank you.
No, you've wrapped it up so nicely, and the hypocrisy of this court is stunning. Uh, and briefly, the Supreme Court is a political animal. The BS that Roberts says the court calls balls and strikes. We're an umpire. Uh, it just falls by the wayside, and it's a political branch. It's justices are appointed by political presidents, and they are confirmed by political senates. And you've put your finger on it, uh, and I really have very little to add to how well you said it. Pamela.
Um, well, all of this is so terribly disturbing, and you make it so crystal clear, and I'm not a lawyer. My particular concern is what is behind the initiative on the immigration policy of the administration. I call him the mob boss. So the premise initially was we must expel all the criminals that are here, the really, really, really bad people, and we must shut down the border. But now we find that I read yesterday that 57,000 people are in prison. The majority, over 70%, do not have criminal records. And I'd really like your thoughts on this as a constitutional expert. It seems to me that what's driving a lot of this, which seems so obvious, is they want to get rid of the minority population, the brown and black population, so that they can push forward their white supremacist, fascist agenda. And I don't see any other way to interpret it. And I'm
Right.
particularly absolutely horrified at sending a bunch of people who have had no due process to El Salvador, where they're literally being tortured for the fun of it. And I don't understand how this fits into American law. And it certainly is the most shameful thing that I can remember since Vietnam. And
Right.
so I'd love your thoughts on how this framing of expelling these bad, bad people to these torture chambers or to places like Africa where they have no roots, no knowledge of that country. So I'd love to hear your
Right.
thoughts on all of that, the constitutional issues.
Thank you, Pamela. Uh, Thank you for reading the question I sent you by email last night so that I could expand on my comments. No, that's a joke. That question was so tailor made because I did want to say that I believe Trump, that immigration is the key to Trump's attempt at an imperial presidency. He and his lawyers think they have hit on the area of law where there is some precedent that the president's power is at its apex when it comes to foreign policy, national security, and immigration. And he is angling to win the Unitarian executive theory in the area of immigration, and then expand it to all of the other areas. And he's playing purposely in multiple courts. So I think he has invented a foreign invasion purposely to come within the Alien Enemies Act, which we don't have time to expand on, but it speaks of an invasion. Um, and to grasp the greatest amount of power. And you've put your finger on the voting electoral wing of that, to disenfranchise and scare people out of this country who might otherwise have a right to vote or who are on a path to citizenship to vote. And he is predicting they would vote against him and the Republican Party. I'll use this moment to just mention the third branch because the title of my talk included Congress. Much of what I've said today is in defense of Congress. The dissenters are defending Congress and the separation of powers because we would have expected a Congress to speak up in the last 6 months. We would have expected amicus briefs from Congress saying you are stepping on our toes. We said good cause to fire a inspector general and a member of the NLRB, and you're violating Congress. Instead, this supine Congress has been so complicit in this, and then they've been actively complicit in not enforcing the War Powers Act, and we haven't even touched on the use of presidential power to attack Iran and the silence of Congress. So Congress is not doing its job. That's leaving a vacuum which Trump is filling, and the Supreme Court is ratifying. Anthony and Pamela, if you take your hand down.
I've just two questions. One is, we're celebrating the victory that took place last week with the case that Mohammed Tajjar and the ACLU successfully defended and against ICE. And his since then, there's been a reduction in ICE raids, and he has said that he's hopeful that this decision may have had some impact. So I'd like you to comment on that. The second is a bigger question having to do with how the structure of government has been altered by the Supreme Court, and now that might be beneficial if a Democrat is elected president. For example, if the Supreme Court is going to be consistent with the unitary executive theory, if there were a Democrat in office and the Democrat were to say, president were to say, I'm going to grant amnesty to every single undocumented person in the United States, much as the president today has granted a gold card opportunity to any wealthy person who wants to become a citizen. Presumably, the president then has the power to grant citizenship to everybody who's undocumented. So that's a sort of a big idea, but would you say that that's wishful thinking, or the Supreme Court is simply so partisan that if a Democrat president were to be elected and apply the same, do the same things that a Republican president did, the Supreme Court would simply say, no, you can't do that because blah, 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 blah.
Right.
These are just my thoughts right now because I'm trying to be hopeful and think that maybe the Democratic president could undo some of the mischief by using the powers that have been granted by the Supreme Court to a Republican president. Is that just wishful thinking on my part, or do you think there's any possibility that might happen?
Yeah. So two answers to each of your very good questions. The first, kudos to our friends at the local ACLU in Southern California. Classic example of the lawyers that I'm applauding today. And rightfully so, because the rulings they are winning are legally based, they are factually based. In this case, I hope the Ninth Circuit will uphold it, but I cannot sugarcoat my concerns about the U.S. Supreme Court and what they will do when that case and cases like it reach the Supreme Court. So I shudder to think as that plays out. And I want to say out loud as a preview to how are we going to fight back. I think I've said it before here. All of this litigation, that we're proud of in the lower courts is necessary but not sufficient to save democracy. Everything I've said today by definition had to dwell on the judicial cases, and that was my purpose today. But we cannot leave this to the lawyers. We cannot leave this to the judges. And that's why the activism of ICUJP and the others we'll talk about is so important. Having said that, it's indispensable what the ACLU and these other groups have done in the last 6 months. Now, to your second part, and you know me largely in the First Amendment area, and I am plagued by the universality of the Constitution. I apply the Constitution without favor. I apply the First Amendment to the Nazis marching in Skokie and the civil rights workers marching in Montgomery, Alabama. I will oppose the unitary executive theory in the hands of a Republican president and, if abused, in the hands of a Democratic president. I don't think this is a training session for an authoritarian, fascist, democratic administration. And so I will argue as vociferously to the next Democratic president as I am today. And I think we have to be very instrumental in thinking in those terms, because we've got to be better than the right wing. We've got to be better than the fascists. And we're certainly not going to implement fascist doctrines and fascist techniques when progressives retake the White House. So now that comes with thought and deliberation and thinking about, there were executive orders on forgiving student loans and others that the Biden administration issued, and each one has to be judged on its own merits. And I would certainly do that in the future with whatever a Democratic president does. Rick.
I think this has been a very interesting talk. One thing that jumped out at me when you were presenting, excuse me, um, when the previous administration was in office, the Supreme Court said that they couldn't do executive actions on student loans, financial environmental regulations, but now they're saying that they couldn't do that without the approval of Congress. But now they're saying that this current administration can completely gut all, the Department of Education and other departments, cabinet level departments, without the approval of Congress. So for me, that demonstrates the complete politicization of that supermajority. So, I think because of that, and when you talk about the next Democratic administration, I'm sincerely hopeful that there will be that the process of electing officials in this country isn't harmed by any political party that's in power or blunted. So maybe you're a little bit more you're a little bit more hopeful about that than I am. But yeah, how is there a way to put that dichotomy of Supreme Court decisions in stark relief, and is there really no recourse at this point? to get some balance there.
Let me use that quickly to preview or to talk about fighting back. It's a political system. We're going to have midterm elections next year. It is possible to take back the House and the Senate. Many of us are going to have to, hold our noses and vote for the lesser of two evils in certain congressional districts and in 2028 in the presidency. And this group debated that fully when it was Kamala Harris and Joe Biden before her. But if we can deny a Republican majority in the Senate, we can block Supreme Court justices. And we're going to have to be that brutal and that Mitch McConnell-esque to use that kind of power. And then, of course, take back the presidency. Justices may have permanent terms, but they won't live forever. My greatest fear, to preview it today, is that early next year or late this year, Alito and Thomas and/or will resign from the Supreme Court, and Trump will nominate young reactionary judges who will live for 30 years on that court if approved by the Senate. So that's why it's the Supreme Court, stupid, and we have to care about that. I'm going to apply a rule I apply when I'm a chair. Shorter answers, Mr. Speaker, and I'll take two questions and see if they coalesce at all. Carol Francis and then Grace.
Okay, thank you. Very briefly, you were talking about the separation of powers, and it reminds me of when Andrew Jackson, when John Marshall's Supreme Court ruled that he couldn't send the Cherokee Nation off on the Trail of Tears. Jackson said, John Marshall ruled this way, let him enforce it. And when I read that, I thought, isn't it unconstitutional? Because we all learned that the president's supposed to be carrying out what the Supreme Court says. And I'm wondering if you can give examples like that when we've had fascist presidents in the past. What happened then, and how can that apply now? Was there a movement against these things in the past?
Good questions. Grace.
Thank you, Steve, for a really, really good, very succinct presentation. I could take all day, actually, but thank you so much. It's really helped. One of my questions has already been answered, which has been in relation to what can we do aside from funding the ACLU and Public Citizen and, writing and calling on and activism is basically the only other road open to us. I appreciate that you did bring that up. My question has to do with, I was quite annoyed at Biden for not expanding the Supreme Court at the time. And why didn't he do that? And what is the advantage of, or why is there so much hesitancy on the part of Democrats to do that? Because I would think that Trump may actually do that, to just stick in more of his people at this point.
Good. I'm going to take more. I'm taking good notes. Is it Ada?
Ida, thanks. My question is, 9/11 really changed my life in terms of getting me into an anti-war activist, and I also saw Bush expand presidential powers at the time and do a lot of the things that Trump also did, which is, like firing U.S. attorneys for political reasons and secret prisons, all these things that we see today. And so my question is, one, how much of that has affected or allowed Trump to do what he's doing now, kind of laying the groundwork? And then the other question is, the Democrats had opportunities to curtail these powers, but they didn't. So what would you say, how can we have a list of demands of like certain, executive powers being rolled back, rolling back the Patriot Act and things like that, and FISA expansion that we can prevent this from happening in the future? Thank you.
Excellent question. Jamie.
Hi. Yes, I really appreciate the discussion and also the questions. I mean, one question that I had, I mean, maybe this will be in the activism session, but you mentioned that this is fascism. What does that mean? And related to that is you made the point about a constitutional crisis. What are the implications of that? And then related, I don't know if you wanted to speak more on this, but the significance of the fact that in this birthright citizenship, when they did the overturning of the injunctions, that has bigger implications than just in this case in terms of what the significance of that is and the danger of that. So I don't know if that's related to the constitutional crisis and this question of fascism being a different form of rule. So that's my question.
Good. Let me march through those. First of all, I did a little bit of research, Carol Francis, and historians are saying Andrew Jackson never said that. That a governor in Florida said it because I believe that wherever the jurisdiction was. So let's both research that. But I understand the underlying theme. It's usually raised, and we said this in the first month of Trump's new office. What if the Supreme Court rules against Trump? They don't have an army to enforce it. And we all scurried about looking at could the Secret Service be pressed into service to enforce the Supreme Court's decision? It is still a dilemma, but ironically, it slipped away because the Supreme Court largely has been upholding what Trump is doing rather than ruling against him. The system depends a lot on mutual respect and abiding by the law and not waiting to be enjoined. And we've had clashes with authoritarian presidents in the past, and we could do a whole day on that as well. You can impeach justices. That was in the chat. And golly, what Justice Clarence Thomas is doing and his corruption and fraud is a high crime and misdemeanor. But impeachment requires the House and the Senate, and it's 2/3 in the Senate. And no one believes we could mount that. And Trump even used failed removals. He was impeached, that you impeach in the House, but you remove in the Senate. And he used that to build up his base last time. So there's a lot of concern about whether we should launch a new impeachment. Shame on Barack Obama for running for office to say he would hold George Bush accountable for his crimes and say we have to move on. And he didn't even open a commission. He didn't even instruct his Department of Justice to look into the crimes of Trump, of Bush, and all of them. And that questioner is right. It set a precedent not to hold presidents accountable, and then it set the stage for criminal immunity. There are reforms under Obama and Biden. We should have amended or repealed the Espionage Act of 1917 that was used against Julian Assange and other whistleblowers. We should have repealed or amended the Alien Enemies Act that's now being used to deport. We need to do, and someone may have put this in the chat, we had a to-do list when those presidents came into office, and they squandered their time, and they didn't appoint district judges when they had the chance to. We are in a constitutional crisis for all of the reasons I've explicated. Fascism comes in different styles in different countries at different times. And we saw it in Italy, and we saw it in Germany. We're seeing it in other countries. And we could rattle those off and have an entire talk about international fascism. And this is American style fascism today. This is what it looks like. It can happen here. I largely have, but look at the time. Ladies and gentlemen and others, fight back. Join organizations that are fighting back. Join the ACLU's People Power, their Know Your Rights sessions, immigration associations, CHIRLA, and the other groups that are doing Know Your Rights work. A woman up here in Sonoma didn't join this program today because she's accompanying an asylum seeker to his hearing in San Francisco because she was trained in that by Indivisible and other immigration rights groups. Indivisible has called for the 1 million rising. Google it. There are training sessions to be part of 1 million rising. There are plans for hunger strikes. There are plans for a general strike borrowed from the American labor movement that began in Seattle and swept the country last century, when we all put our hands in the machine to stop it, to not cooperate in an economy that's destroying lives and killing people. There are banner drops planned for Labor Day. There are movements to boycott Whole Foods, Amazon, still boycott Tesla and demonstrate against Tesla. This is scratching the surface of the kind of activism. ICUJP is holding continuing demonstrations. Erica Chenoweth, thank you, Anthony Manousis, is now a household name among activists. She appeared at a national meeting of Indivisible explaining that 3.5% of a society, when they mobilize, organize, and resist, can change public opinion and change public policy. So we need multiple pillars of activism. We need to be in the streets when that's what we need to do. We need to be at our elected officials' offices lobbying. We need to remove Chuck Schumer as majority leader by public outrage. We need to support filibusters when they happen in Congress. We need to applaud when elected officials do the right thing and condemn them when they do the wrong thing. And each one of us needs to do something on the list I gave you and what ICUJP will be telling you about in every one of these Friday forums until we have recovered our democracy, of how you need to speak up. The Constitution begins with the words, we the people. It doesn't say we the courts. It doesn't say we the legislature or we the president. It's we the people. We've got to believe that. It is activism that is an antidote to hopelessness and despair and cynicism. And it is only when we stand shoulder to shoulder, whether it's in the street or on a Zoom screen, that we will actively take back this democracy. Trump and his ilk depend on cooperation, on compliance, on surrender. That's how fascist movements have succeeded, and we cannot let that happen in the United States of America. It is not a perfect system. It was built on the original sin of slavery and the exploitation of Native Americans. But it had within it the principles and the ideals that we can live by if we will live by them. And every one of us, and I do this, and I said this at ICUJP when my grandchildren were little babies, and one of them just graduated from Vanderbilt University, and I have two little ones at 4 and 8, and I've said they gave me this name, Peepaw, as my personal grandfather name. And I have said here, they will ask me, and they are asking me, Peepaw, what did you do back then? What are you doing now to protect me, your grandchildren? We all have those children directly and by birth and by adoption and by faith and belief in our children, our grandchildren, and the children in this country and the children across this world that we are responsible for in every place across this world, and in Gaza and in Iran and in the Ukraine and everywhere that children are dying because of authoritarian governments. That's our responsibility. You cannot put your head on the pillow tonight unless you've done something against that. And you need to wake up tomorrow morning and promise to do something for justice and peace. Thank you so much for taking your time, for indulging me past 9:30 to do this. You know I stand with each one of you to do this work. And I thank you, and I am so grateful this group has done this work for 24 years. We are built for this. We are in this for the long term. Thank you, and I give it back to Rebecca.
Preach it, Steve. You sound like a preacher in the pulpit, so way to go.
Thank you, Steve. Thank you. That was it was so inspiring. We have our direction, we have our guidance from you during these troubling times. During these troubling times, you are a bright beacon of light. And leadership. So thank you. Okay, so Steve said we are running over time, but this was well worth staying for, as you see. And of course Steve is our chair, so he's already a card-carrying member of ICUJP, but I would call him our chair emeritus at this point. We really uphold him high.
Friends, thank you so much for this day. I want to thank Steve and all of you. It's just during this difficult time, I'm so grateful that we're together. So I want to begin by giving my thanks to the spirit of truth and love and peace that unites us to each other and to everyone else in this planet. I want to lift up the people who are mentioned today who need our prayers and our love and compassion, especially those who've been taken up by ICE and those who are living in terror in Gaza and other parts of the world that are torn by war. Let us never forget them. Let us never stop advocating for them. Let us never stop holding them in our hearts. And I'm grateful for those who are using their skills as lawyers to fight for justice. I'm grateful for the activists who are putting their lives on the line. And I just want to lift up today all of us, continue to inspire us, to challenge us to do the best we can to make this world a better place for our children and grandchildren. I ask this in the precious name of the one who created and sustains us.
Thank you. As chair now, I'm thanking Rebecca. I'm thanking her extraordinary opening, and I've said everything it's on my heart now. Please come back to us next week for that important speaker, Heidi Bogosian, and come back every week and tell people about it. New people are joining ICUJP each week. So talk about this program. This will be posted on our website shortly, and push it out to others who were not able to join us today. And do all of that in solidarity and in the spirit of peace and justice. Thanks, everybody.